Good morning, guys. Pooja, Tejal.
Hello, ma'am.
Hi. Okay, so do you guys have any questions with regards to admin? I know that your test marks are out and you have the class assignments to do if you haven't completed 1 and 2. Remember, you have to complete 2 in order to get your 10% at the end of the semester.
Yes.
Okay, all right, so we're all good. So this week, we're going to be dealing with lease agreements. So just like all the special contracts that we've been dealing with, a lease agreement or a contract that pertains to lease is also a special contract, and it also has requirements that need to be in the contract to make it a lease agreement. So there are 4 parts to this lecture. We have lectures 1 to 4. In lecture 1, we're going to be dealing with the relevance of lease. We're also going to be dealing with capacity. We're going to be looking at who has the capacity to enter into a lease agreement. We're then going to be looking at the essential elements of contracts of lease. There, we're going to be looking at the object of the contract. We're going to be looking at identifying the leased property. And we're also going to be looking at rent, okay? So if you want to refer to your textbook, lease agreements begin at page 241. So the relevance of lease is a contract through which one party, the landlord, who is referred to as the lessor, gives the temporary use and enjoyment of the property to the tenant, who is the lessee, in respect for payment of rent. So we know that the parties that are involved in a lease agreement are the lessor, who is the tenant, the landlord, and the lessee, who is the tenant. And the lessee then needs to pay rent. The landlord needs to give the lessee temporary use and enjoyment of the property. So a lease can be entered into in respect of both movable property and immovable property. With immovable property can be commercial, industrial, or residential property. With your movable property, you find that when you visit your bigger companies, your very big companies, they actually lease out those photocopying machines, okay? Those scanning photocopying machines. So that is a contract of lease that they've entered into. For example, if they've entered into it with Nashua, okay? So that is a contract of lease. So it's both for movable and immovable property. So when we talk about contract of lease or lease agreement, it is governed by common law. And it has a certain level of statutory intervention. So you'd find that there are some other acts that deal with your lease agreements. However, if you are looking at residential leases, so if you're leasing a property out, or if you are the lessee and you are seeking to lease a property from the landlord, that particular agreement between the landlord and the tenant will be governed by the Rental Housing Act. So remember, generally, contracts of lease or lease agreements are governed by common law. However, when we talk about residential lease, it is governed by your Rental Housing Act. Let's now look at capacity. So ownership is not a requirement for a person to be able to lease out the property, because we know that some people make a business out of subletting. What is subletting? Say, for example, I don't own any property, but I go into town and I see a business opportunity, because a lot of students live in town because they want to be closer to campus. So what I do is I lease out a particular block of flats, and I will be the lessee, and the person who owns the flat will be the landlord, who is the lessor. So I then lease it out to someone else or other people, that's students, and that will be now a new contract where I will be the landlord and the students will be the sub-lessees. Okay, so it's two different contracts. So I don't have to be the owner of the property in order to let it out to someone else. So the landlord does not have to be the owner of the leased property. For example, a tenant can sublet the property. But remember, you can only sublet a property that does not belong to you if in the agreement, in the initial agreement of lease, the initial landlord has agreed to you subletting the property out to someone else. So in South African law, all the landlord is all that is required from the landlord is to warrant that there is no person with a superior right in the property who will disturb the tenant's use and enjoyment of the property, but they do not need to be an owner of the leased property in order to lease it out. Let's look at the essential element of the contract of lease. Very important. If you are taking down notes, please write in B or put an asterisk next to it. You need to know this. So typically, there needs to be agreement on the following between the landlord and the tenant, the lessor and the lessee. Firstly, the immovable property that needs to be leased out needs to be specified. Secondly, there must be a duration of the lease period. Remember, lease is different from sale because in sale, the parties or the seller is giving the buyer permanent use and enjoyment of that particular property that is being sold. But in lease, it's temporary use and enjoyment of the property that is being leased out. So there has to be a duration because it's temporary. It's not something that will go on forever. And lastly, specified rent. The rent must be specified. So the purpose of lease is for the landlord to hand over temporary use and enjoyment of the property to the tenant. And this is a distinguishing feature from your contract of sale, where permanent transfer is given to the buyer. And in return of the temporary use, the tenant then pays rent to the landlord. So as a result, there are three areas in which the agreement must be reached for a contract of lease to arise. So firstly, the object of the contract that must be leased. Secondly, we must identify the property clearly. And thirdly, rent must be paid. Let's go into detail with each of these essential requirements. So firstly, the object of the contract. So use and enjoyment of the property is transferred for a limited period of time only because we are talking about lease and we're not talking about sale. The rights acquired by the tenant in respect of common law are to use the property and the rights to the fruit of the property, but not take away from the substance of the property. So if you are leasing out a property, say for example, it's agricultural land, you have the right to use and enjoy that property. You also have the right to the fruits of that property. For example, if you are planting sugarcane, you have the right to the sugarcane because the sugarcane is fruit of that particular property. But as long as that particular fruit does not diminish the substance of the property, does not deplete or take away the substance of the property. So lease of mineral rights do not fall under common law, but are governed by statute. The property is the subject of lease and must be identified or identifiable. So a typical example with regards to the property being identifiable. So you know that if we identify the property, say for example, you are looking for a property to lease out because you want to be closer to campus. So the landlord then takes you to view the property. Identify the property, you see how many rooms there are, you see where they are built-in cupboards or there's furniture. So it's identified, you know where it is, it's identified. But identifiable means that, for example, you meet with the landlord at Starbucks and you discuss that he is going to let out his property to you for an amount of maybe 3,000 rands a month as rent. And how is the property identified there? By the landlord giving you the address of the property, where the property is situated, or can give the title registration number, the registration number that appears on the title deed, to show you that this is how you can identify the property. So in addition, the parties must be of the same mind in respect of the property that is to be leased out. Still with the identity of the leased property, the following general assumptions arise unless the contract provides otherwise. Firstly, if the land is let out with reference being made to immovable structures on it, they form part of that lease. And secondly, if the entire building is let without a reference to the land on which it stands, the land forms part of the lease. And these are general assumptions that come about with your contract of lease unless it is specifically provided otherwise. So if the portion of the building is let out, then the tenant will not have the rights in the land other than the right of reasonable access to the land. And the contents of the building are not normally subject to the lease unless stated or intended by the parties. So another example, you go and lease out the property, you find that there's a chair and a desk in that immovable property, okay? The content in that particular property, which is the chair and the desk that you find there, will not normally form subject of the lease unless the parties then state that the building maybe comes with furniture or otherwise between the parties. Let's look at the rent. So the basis of a lease agreement is an amount in rent payable by the lessee. Remember, the lessee is the tenant, to the lessor, who is the landlord, in return for the use of the property. And if there's an agreement allowing the use of the property without payment, then this will be a loan and it will not amount to a lease. So rents must be fixed or must be defined. So the parties can agree on a definite amount to be paid as rent, or the parties can agree that rent will be the same as payable by the previous tenant, or that it will be the usual rate for the premises, provided that the premises are regularly let out to people, or the parties can then agree that a named third party will come in and stipulate how much of rent will be paid. All of this will amount to rents being fixed and rents being definite in that particular contract. The parties can agree that rent will include a share or all of certain other expenses such as your rate and your maintenance. So you'll find that usually the landlord is the one who is in charge of maintaining the building. But if the parties, the lessor and the lessee, agree that maintenance will be carried out by the tenant, then so be it. Rate as well, okay? Usually you know that rates are paid by the landlord, but if the parties agree, because there's freedom of contract, parties can agree otherwise. So it is essential that there should be an agreement in respect of rent, and therefore one of the parties cannot be given an unfiltered discretion to fix the rent. The lease, with regards to the rents being in terms of money or in terms of fruit, we know that rent must be, that's a general rule, rent must be in terms of money. However, there is an exception to that general rule, that if we are talking about your agricultural land, rent can be paid by means of fruit. Again, with an example where you are leasing out agricultural land and the person farms on the land, you can say that rent can be by way of by fruits. If it's sugarcane that you are farming on the land, it can be by way of sugarcane. So many tons of sugarcane will amount to rent, but this is only applicable on agricultural land. It's not applicable on residential land. Residential property, rent must be in money. So the lease of an urban property, whether commercial, industrial, or residential leases, must comprise an agreement to pay an amount in money as rent. The exception to this is if you are leasing land for agricultural purposes, the parties can agree to rent being paid in money or in fruits. So payments in fruits means that the rent can either be definite by the quantity of the produce or agreed portion of the gross of the produce. So only when we talk about agricultural land, parties can say rent can be paid by way of fruits from that land. The rent must also be genuine. So this requirement does not mean that the nominal rent will always void the contract, but the genuineness of the parties will look at the intention of the parties. So the law would always look at the true intention rather than the form of the transaction between the parties. The duration of the lease, during the lease, it is possible to change the amount of rent. So you'd find that you sign a 1 year's lease with your landlord, and the landlord says, should you renew the lease, the rental amount will increase by 10%. So it's possible to change the amount of the lease. So the landlord may also agree to reduce the lease at some point. And we saw this happening when we were faced with COVID-19 and people lost their jobs. So landlord needed to accommodate their tenants, and in fact, they reduced their lease and they were not charging the same amount that they normally charge. So your legislative provision pertaining to residential leases, we know that the law that deals with your lease agreement is common law, but when we talk about residential property, we look at the Rental Housing Act. The Rental Housing Act deems that certain provisions need to be included automatically in a residential lease. So even if the parties do not discuss these terms or do not agree on these terms, they will automatically be in the contract. They will be imposed in the contract. So firstly, the provision of receipts. So if you are paying rent, you need to get a receipt back. Secondly, deposits. Deposits must be paid and kept in an interest-bearing account. This is per the Rental Housing Act. And thirdly, inspection of the property, inspection before the tenant moves in, and inspection after the tenant or before the tenant moves out. So inspection is usually done by both parties, where before the tenant moves in, then the landlord and the tenant will both come to the property and indicate what are the defects to the property, so that when the tenant eventually moves out, we know that when the tenant moved in, this was already damaged, it was a defect, and it was not caused, or the damage was not caused by the tenant. Because remember, if it was caused by the tenant, then the deposit is used to fix that damage. So according to the Rental Housing Act, the inspections must be done. Can I get a thumbs up that you guys are still with me with regards to the topics that we've covered for lecture 1? Okay. Let's look at lecture 2. Okay. So for lecture 2, we are going to cover the duration of the lease. We're also going to cover renewal of the lease. We're going to cover termination of lease. We're going to cover the Hoerkraat Voorkop. We're going to cover subletting. And it's from page 250 onwards. So let's look at the different durations of lease agreements. So the parties will normally agree on the duration of the lease, and this will take many different forms. We have a fixed lease period. We have a lease period until the happening of a certain event, or a periodic lease period. Let's look at the different durations. So when we talk about a fixed period lease, the parties, they agree that the lease will run from a definite time period and it will stop running at a specified time period. So the parties, the tenants and the landlord, agree that on the 31st of September 2018, this is when the lease will begin. This is when you will move in with all your property, okay, all your furniture. the lease will end on the 18th of October 2019. So we have a specified start date and a specified end date. Okay, then we have a lease period or duration until the happening of a certain event. Okay, for example, you have a property, okay, and you want to let it out, but you want to let it out until the happening of an event. So maybe you have a child who's now 17 and is ready to go to university the following year, and the property that you own is close to university. So you give this person an opportunity to live in your property, and you say that once my child has finished with matric, you will have to move out. The lease will end because then I want my child to move in and occupy the premises. Okay, so it's until the happening of a certain event, and once that certain event occurs, then the lease will come to an end. Or we have a periodic lease. So with a periodic lease, it can run from week to week, month to month, a year to year. So a periodic lease may be expressed, it may be tacit, it may be implied. You'd find that mostly the periodic lease will occur when the parties agreed on a fixed period. Okay, maybe they say the lease agreement will run from the 28th of November 2021 till the 28th or the 30th of October 2022. And after the 30th of October 2022, the tenant has not renewed the lease. The landlord does not even question why the tenant has not renewed the lease. They continue the following month, the tenant pays rent and the landlord accepts the rent, and no one is talking about the renewal of the lease. You'd find that a new lease then comes about, and that new lease is a periodic lease, and it is not now a fixed lease. That fixed lease would have terminated when the specified date had come. So a lease will end at the will of the landlord or at the will of the tenant or either party. So it only terminates when a person whose favor the lease is in gives notice, or when one of the parties die. Let's talk about renewal of leases. So with your fixed period leases, they're often renewed, and renewal may be expressed or it may be implied. So with your implied renewal, so implied renewal is usually referred to as a tacit renewal, or as a tacit relocation, and it generally occurs after the expiry of the date of the original lease, and the tenant remains in occupation of the property, and the landlord, knowing that the lease has come to an end, accepts the position and continues to regard the property as or the other party as a tenant, and does not actually remove the tenant from the property. So with your tacit and implied renewal, generally it occurs after the expiry of a lease, like we have mentioned, where the original lease had expired and the tenant remains in occupation and the landlord accepts the rent from the tenant. So if the landlord is not in content for the tenant to remain in the leased property, then it will be unlawful occupation because the landlord is not happy with you being there. An option to renew, typically a lease agreement will provide that within a specified time, before or after the expiry of the lease, the tenant may renew the lease for a specified amount of time. The landlord is prohibited to offer the premises to any other person until it expires. You find that sometimes before you even sign that lease agreement, whilst you're reading the terms, okay, one of the terms will say that we have an option to renew. It's similar to an option or a right of preempt that we dealt with in your law of contract. So the landlord actually gives the tenant the right to renew the property and will not advertise the property to anyone else before the tenant had either agreed to renew the property or had refused to renew the lease to the property. So an option to renew, must be distinguished from a right of preempt to purchase property, even though they fall under the same category. So the right of preempt is a contractual right afforded to the holder the first opportunity to purchase the property before it can be offered to another buyer. Whereas an option to renew is with regards to or attached to the lease agreement, where the landlord gives the right to renew the lease to the property first to the tenant. So in other words, with the right of first refusal, it attaches to your law of contract, and your right to renew attaches to your contract of lease or lease agreement. Let's look at how your lease agreements may terminate. So they may terminate by the expiry of the period. So with your fixed period, when a specified date comes about, then we know that the lease can terminate. So in terms of the Consumer Protection Act, the landlord must provide notice of the termination to the tenant. And also in terms of the Consumer Protection Act, a fixed term lease may only operate for 2 years, where after that, there will be a month-to-month that kicks in. Can also terminate by notice before the fixed date comes. Maybe you get a job in another province, you have to now give notice to terminate that lease. So notice of termination is a unilateral act and is not an agreement. So once the notice is given, it cannot be withdrawn without consent of the other party. Death can sometimes terminate a lease. So generally a lease does not terminate upon death of either party. This is beyond our scope, but you'll have to see the textbook on lease at the will of the tenant and lease at the will of the landlord. Okay, insolvency of a tenant. So generally the lease is not terminated by insolvency of the landlord. However, if a tenant is declared insolvent, remember, a trustee then takes over the property or the assets of that particular tenant. And if the lease agreement is to the detriment of that insolvent estate, then the trustee will have to terminate that particular lease. Okay, the trustee will have to give 3 months notice after they have been appointed, or within the 3 months that they have been appointed as a trustee of that particular tenant, to terminate that lease. So you'll usually find this where a person is leasing out a whole, maybe hotel. Okay, if it's to the detriment of that of the tenant's estate, then the trustee may, within the 3 months of being appointed, terminate that lease agreement. Expropriation is another means of terminating a lease agreement. Impossibility of performance, so where it is there's complete destruction of the subject matter without the fault of either of the parties, there will be automatic termination of the contract. So you'd find that maybe you are leasing out a premises and you decide to go on holiday. The floods hit, the property is swept away. When you come back, there's no property to lease, okay? There's impossibility to continue with that contract, so that lease will automatically terminate. Let's look at the Hoogstraatvoorkop clause. So there are no formalities that are required for the validity of a will between the landlord and the tenant in respect of leases of Land Act. A lease can therefore be verbal, as parties have to only reach consensus with regard to the essential elements. And should the parties wish to agree on further terms, they can, because of the right or the freedom to contract. But difficulties arise where the owner of the property, who was the tenant, sells the property whilst or within the duration of the lease. So now we have a new owner. There's someone who's leasing the property. What do you think? The new owner has a right to terminate that particular property. But in Roman law, if the lease property was sold, then the new owner could evict the tenant. In Roman law, a different approach arose because there was injustice done to the person who was leasing out the property. And this new approach is called the Hoogstraat voorkoop, which means that the lease comes before the sale. So if a person sells a property to which he's leasing out to someone, the new owner, the person who's buying the property, will have to stand with the contract of lease up until its termination. Okay, they cannot readily cancel the contract because it's prejudicial to the person who's leasing out the property. So remember, lease comes before the sale. So the lease will take precedent before the sale kicks in. So the successor on the transfer is the person to whom the rental is applicable, meaning the new owner is the one who will now receive the rent. So the new owner will step into the shoes of the old owner and will have all the rights and responsibilities with that contract, or let us stipulate it in that lease contract. Okay, they will receive the rent. If they have to maintain the building, they will have to maintain the building. The successor acquires all the rights of the landlord that the landlord would have had in that initial lease agreement, and the successor also succeeds all the obligations owed by the original landlord and becomes bound by all the material terms to that lease contract. Let us now discuss subletting. Okay, so we spoke about and we gave an example of what subletting could be, where you are not the owner of the property, but you let it out to someone else, provided that the contract, the initial contract where you are the lessee, where you are the tenant, provides for subletting and allows you to sublet the property. So now there are two separate contracts. We have the first contract being with the original landlord and yourself, who is the lessee. Then we have a separate contract, the second contract, where you are now the tenant and there is a sub-lessee who now reports to you. And remember, in that second contract, you have the obligations to maintain the property. If according to the contract, you need to pay rates to the property, you'll pay rates to the property. And also the rights will also accrue to you as the new landlord. So you'll receive rent, and in turn, you must keep your obligations with regards to the first contract, meaning that you will need to pay rent to the initial landlord. So a sublease is a contract whereby a tenant leases to someone else all or part of the property which they have leased. A tenant is now the landlord in respect of the sublease and gives the rise to rights and obligations of a new lease. And the original lease remains in operation with no change to the identity of the parties. So the sublease is a contract whereby a tenant leases to someone else part or all of the property that is being leased out, and the sublease forms a separate lease, and there is no legal connection between the original landlord and the subtenant. So if the subtenant has a problem or has an issue or there's a burst pipe, the subtenant will then report to the lessee, who is now the landlord and not the original landlord. So the tenant of the original lease remains obliged to pay the rent. Okay, can I get a thumbs up that you guys understand what we've covered? Okay, let's move on to lecture 3. And here we're going to be speaking about the duties of the parties. Remember, the parties to the contracts, you have the landlord and you also have the tenant. We're also going to speak about the remedies for breach. For example, if the tenant does not pay rent, what remedies does the landlord have against the tenant? If the landlord does not maintain the property, for example, what remedies does the tenant have in those particular instances? You can have a read from page 261 for this particular lecture. So duties of the parties, the rights and duties between the parties may arise either by operation of the law or from an expressed or implied agreement between the parties. So the law might impose some rights, might impose some obligations, like we saw the Rental Housing Act imposes some obligations that deposit must be paid, receipts must be given, inspection must be made to the property, or it can be expressed or implied by the parties. Expressed where now the landlord says you are going to maintain the property. So it's expressly agreed upon between the parties. Implied, if you had agreed to rent out a particular property, a vacant property with no furniture, but you find a desk and a chair and you end up using it, it's implied that that lease now incorporates that particular desk and chair, okay? So those that arise by law can arise by common law obligation or residual obligation or naturalia. So however, the parties are free to agree to the terms which override the common law terms, although the courts are cautious in interpreting these clauses. Remember, freedom of contract. So even if the law gives us standard terms that needs to be in a contract, they may be changed by the parties as long as they are not extremely detrimental to the other party. Let's look at the first obligation or duty that the landlord has, which is the duty to deliver the leased property. So delivery of the use and occupation of the leased property at the time agreed upon, the landlord must deliver the use and occupation of the leased property to the tenant on the due date, termed the duty to give vacant possession. So the landlord must give you vacant possession. By vacant possession, usually we mean that there must not be anyone else occupying the property when you or on the due date when you are supposed to be given the keys to occupy that particular property. So if someone is in unlawful occupation of the property, the landlord must evict that person. So it's not the duty of the tenants to evict a person who is there unlawfully. It is the duty of the landlord. It is also the duty of the landlord to deliver all the things without which the property cannot properly be used, such as the keys. So the landlord must give you the keys to the door. If there are many rooms in the house, the keys to each door. Okay, the landlord must give you access to water. I mean, the property must have access to water, must have access to housing. I say access because you know that sometimes you have a metered electricity, so you'd have to buy your own electricity, but there must be that facility that allows you to access the electricity, access the water. Okay. And if the landlord fails to deliver the use and occupation, the courts are prepared to order specific performance. What is specific performance? Specific performance is basically the court saying that do as you agreed in the contract. So the performance that you specified in the contract, do it. So the courts may order the landlord to specifically perform as they agree to the contract, because in the contract of lease, they have agreed to give temporary use and enjoyment of the property. So they must do that. So if there is already someone in lawful occupation, then the tenant may have to be content with claiming your damages unless it can be proven that the person took occupation knowing the lease, knowing that there was a lease in place. So we find that maybe someone else, maybe there's fight in the family and this one person decides to lease out the property that is occupied by one of the family members, and that family member is in lawful occupation of the property. So if you get there and you find that someone is in lawful occupation of the property, there is nothing else that the courts can do. They cannot say to the landlord, perform as you specified, because this person who is occupying the property is in lawful occupation. The only thing that the courts can say is that you can claim damages. So say, for example, if you have hired a truck that will move your furniture from point A to that new property, maybe the truck people charge you 1,500 Rand, you can claim damages for 1,500 rands. If you have missed a day of work and your boss had said you're not going to be paid for this day, then you can claim for the amount of money that you're going to receive from work on that day. That's only what the court can give to you, and they cannot say to the landlord, perform as specified in the contract, because there is someone who is in lawful occupation of that property. So if the landlord refuses to deliver, then the tenant may choose to take legal action to cancel the lease and claim damages. So say the court then orders specific performance and this person does not perform. As the lessee, you can choose to cancel the lease and claim damages for whatever losses you have suffered in preparing to move into this property or in preparing to receive this property. Remember, we're mostly talking about immovable property and residential property, but lease agreements can also apply to your movable property. So another duty of the landlord is to keep the property in proper condition, which means to maintain the property. So the leased property must be kept in a condition that is reasonably fit for the purpose for which it is let out. And there are two aspects to this duty. Firstly, the commencement of the lease, and secondly, the maintenance during the lease. So before or during or on the day of commencement of the lease, the property must be in a condition that is fit for the purpose which it is laid out for, because in that lease agreement, the lessee then specifies what they are leasing out this property for. So in the commencement of the lease, it must be in proper shape. During the lease agreement, the lease period, the landlord must then keep inspecting the property to check that it's still in proper condition or fit for the purpose which it was let. And the duty to repair structural defects remains with the landlord. Another duty that is owed by the landlord is to protect the tenants against interference in the use of the property. So it is implied that in all leases that the tenant will be entitled to quiet use and enjoyment of the property. And this means that the landlord must not disturb the tenant. So the landlord cannot knock on your door at 12 o'clock at night, because that is disturbing the use and enjoyment of the property. But this does not relate to the conduct of third parties. What this means is that if you had leased that property and the next door neighbor is always having a party and disturbing your use and enjoyment, that is outside of the means of the landlord. The landlord cannot fix that for you. So this duty does not extend to third parties who are now disturbing your use and enjoyment to the property. So the landlord has the right to enter the premises and exit, but should be done only when the tenant permits it. So the landlord must give you reasonable notice that he or she will come and inspect the property, and you must then, as a tenant, give permission. Despite having a reasonable purpose for entering, this does not change the basic rule that the landlord should first request permission. According to the Rental Housing Act, the tenant has the right to privacy, and the landlord may exercise his right in inspection in a reasonable manner and only after reasonable notice has been given to the tenant. Okay, although we say that reasonable notice must be given to the tenants, there are exceptions to this reasonable notice. So there are instances where the landlord does not even have to give the tenants notice or reasonable notice or seek the tenants permission to enter the property. This is where the landlord wants to carry out necessary repairs. Say, for example, there's a burst pipe and it needs emergency or attention immediately. Then the landlord does not need to give, does not need permission from the tenant to enter the property. The lease is near to its end, and when the landlord wants to erect it to let notice. So if you are leaving next month, or if you've given your 30-day notice period and you're serving your 30-day notice period, then the landlord may enter the property and erect a to let notice on the property. And the landlord may not use the pretext of carrying out necessary repairs to in fact make improvements to the property. So necessary repairs are different from improvements to the property. So with improvements to the property, say for example, the landlord wants to now change the color, say that the color of the walls were white, now they want to change the color of the walls to peach. And they say, well, I don't need your permission because this is a necessary repair. That is not a necessary repair. We must then distinguish between a necessary repair and improvement and an improvement to the property. So the landlord also has a duty to pay rates and charges in respect of the property. So the parties can agree that the tenant pays part of or all of the charges. And should the tenant not pay, then the public body will bring action against the landlord. And if the landlords pay, then the landlord has a right to recover against the tenant. Let's look at the duties that are owed by the tenant in a lease agreement. So in the absence of an agreement, we then use common law. So if the parties did not agree on a particular point, we then look at what common law says. And common law says that rent is payable in arrear. So you will live in that particular property for the month of October, and your first rental payment will be done at the end of October. So that is what common law says. But if the parties agree that it will be paid in advance, then we look at what the parties agreed to. If a place for payment has been stipulated, then rent must be paid at that particular place. And if the agreed date has been set by the parties, then the payment should occur on that particular date that is set by the parties. The tenant also has a duty to use the property in a proper manner. This means that the tenants must use the property only for the purpose which it was leased for. And if you had leased the property for residential purposes and you are now running a tuck shop, that is going against what you agreed to in the contract. And the landlord has remedies, a remedy to interdict you, to go to court and seek an order to say you must stop what you're doing, stop running that tuck shop. Or secondly, cancel the contract if it is agreed by the parties that should there be a breach of this nature, then the contract may be cancelled by the aggrieved party. The tenant also has a duty to restore the property in the same condition with reasonable wear and tear that is accepted. So the tenant must take reasonable care of the property throughout the lease of the property. And the question of whether there has been a breach normally arises on termination of the lease, and when the time comes to restore the property, then you'll find that both the tenant and the landlord will have issues with regards to what is wear and tear and what is the damage that is caused by the tenant. So the Rental Housing Act gives the landlord the right to claim compensation for damages to the property that is caused by the tenant or the people who have been visiting him for the duration of the lease. So you'll find that the amount that you pay for deposit is used to fix any of the damages, but if it's not sufficient, then you will have to pay the balance. So remedies that apply both to the tenant and the landlord, they are ordinary remedies for breach of contract. So if the breach is material, the aggrieved party may firstly choose to keep the lease and sue for specific performance, or claim for damages, or B, cancel the contract and sue for damages. And if the breach is not material, then the aggrieved party can sue for damages only. Cancellation is another remedy. So if on delivery, the condition of the property is such that it is not substantially fit for the purpose for which it is let out by the tenant, then the tenants may refuse to take delivery and cancel the lease day. Okay, as a general rule, the tenants cannot cancel the lease if the repairs can be effected within a reasonable time. So where the unfitness of the property is not sufficient, the substantial to justify cancellation will not be there, or the tenant does not wish to cancel, and the tenant must then call the landlord to effect the repairs. And if the landlord fails or refuses to do so, then the tenant may get an order for a specific performance from court, or where the tenant, as a result of the landlord's failure to maintain the property, receives less than a full benefit of the property to which the tenant is entitled, then there might be a reduction of the rent. And also repairs by the tenants can take it upon himself to do repairs. So say, for example, you've notified the landlord that there's a leak in the tap for so long, and the landlord has delayed in fixing the tap. You can get someone who's a plumber to fix it, and you can pay them, and you can minus that from the rent. You can set it off from the rents that you're going to pay. So where the tenant has called on the landlord to repair and the landlord fails or refuses to do so, the tenants may carry out the necessary repairs and claim for reasonable cost of that from the landlord. And alternatively, the cost can be set off from the rent, but only where such costs are capable of easily and speedy proof. So the remedies of the tenants to guarantee the tenant against eviction: the landlord guarantees the tenants will not be dispossessed or disturbed in the use and enjoyment of the property by any person with a better title, and the threat to eviction will therefore not be sufficient to satisfy the abandoning of the leased property unless the landlord agrees. So if someone if you are now leasing the property and the lease agreement is ongoing, and someone comes in there and says, this is my property, it belongs to me, that's a threat. And if you leave the property and you abandon the property because that one person has come and they have requested to take occupation, you will not get the damages, or the landlord will not be liable, because you must give the landlord reasonable time to come to your defense and fight this battle on your behalf. If you merely leave the premises, then you will not be allowed to claim damages from the landlord. So the tenant does not pay rent. In terms of the Rental Housing Act, the landlord may give notice to the tenant of his intention to cancel the lease if the arrear rent is not paid within a reasonable time. So the cancellation clause is an express term allowing the landlord to cancel the contract of the lease on a breach of a specified term, such as non-payment. So we have a rental tacit hypothek that the landlord is entitled to. So if the rent, say for example, the rent is not paid, then the landlord may call about a sheriff, okay, instruct the sheriff to attach the movable property of the tenant and remove it and sell the property in a public auction in order to recover the rent. So with a tacit hypothek over movables on the property, it operates as real security or a real right of security for the landlord, and is completed when the landlord instructs the deputy sheriff to attach the movables and remove them from the leased premises as security for the outstanding amount. Okay, when the property is removed, it's kept in storage, awaiting to be sold in a public auction. So the tacit hypothek is lost if the tenant then removes the property from the premises. So say, for example, the sheriff merely attaches the property, so points out to the property and tells the tenant not to remove any of the property within the leased premises, okay? And the tenant decides, okay, I have a friend, I'm going to move all my furniture to my friend's place, then that tacit hypothek is lost. The landlord cannot go to the tenant's friend and fetch the property in order to attach it. However, the landlord may apply for an interdict preventing the removal of the items. So it is advised that before the landlord removes the item from the property or attaches the items in the property, you must go to court and get a court interdict to prevent the tenants from removing any of the items from the property, then attach them, then take them, remove them, and sell them in a public auction. And it applies to all goods that are brought into the property, either belonging to the tenant or the third party. So if you are leasing out property and your friend has a laptop in your apartment and you haven't paid rent, and the landlord has now went to court, got an order for an interdict for you as the tenant not to remove any property, that property will not be removed and it will be attached together with your friend's laptop. So it applies to all property that is found within that leased premises. So be careful, don't leave your stuff in your friend's leased apartment if they're not paying rent. So if the goods belong to a third party, then the landlord must show firstly that the goods are on the property, and because of the consent of the owner that they're on the property, and secondly, that the goods are for the use of the tenant, and thirdly, the landlord has no knowledge that they belong to a third party, and fourthly, that the goods are on the premises with the same degree of permanence. So these are the requirements, very important, the requirements that the landlord must prove in order to say that those goods or assets are good to be attached because they are there permanently, they have been used by the tenants, and they are, well, the landlord sees them as the property of the tenants because they have been there for a very long time. And to cancel the contracts, the misuse must be serious, and alternatively, the landlord must apply to court for an interdict to prevent the tenant from misusing the property, and the landlord can also sue for damages. And lastly, guys, the tenant fails to return the property at the end of the lease, the landlord can eject the tenant as a trespasser or claim damages, or lease or the lease can tacitly be renewed on the same basis as the original lease. Okay, we've only managed to go through lectures 1 to 4. Please go through lectures 4 and also listen to the recording. Can I get a thumbs up that you guys understand lease agreements? And if you don't, you'll send me an email. We can set up a one-on-one consultation. Okay, thank you so much, guys. I will see you next week for security.